All right, well, I'm live, and this is another one for the fathers. This is the FFF Fighting for Fatherhood group in Facebook. What I'm trying to point out here is our file section here. We got different sections, as you can see, photos and things of that nature. But in our file section, we have what are called the interrogatory sample. And this is what I want to go over. What is the interrogatories? Right here, we look at the juvenile court. This is their local rules. And I want to show one of their local rules to show how they break their rules. As you can see right here, the juvenile court local rules. And I'm gonna zoom it in real quick. Hopefully everyone can hear me. Oh wow. Uh, okay, yeah, they can't hear me. All right, my bad. So right here, we're seeing case files, inspection of case files. So you can get all the case files, but you can get copies of the case files. One thing I'm gonna be doing is getting copies of all the case files. I know I have some, but I want all the copy. I want a copy of the case files. But right here, it says record of hearing, official record. This is one thing that the juvenile court is denying me evidence, and I'm gonna have another video soon to prove without a shadow of a doubt this is taking place. But right here it says inspection of the audio or audiovisual record. So we're talking about when you have a camera in the courtroom. This right here is a Hamilton County local rules. This is the local rules of my court, which don't go by their rules. But if you go down here to part D, it says reproduction of audiovisual record. You go, oh, and let me zoom in some more, man. This is better. Okay. Reproduction of audiovisual record. No copy of an audio or audiovisual record shall be made unless by order or permission of a judge. Any party requesting a reproduction of an audio or audiovisual record shall file a motion with the clerk. The judge assigned administrative responsibility for the case may schedule a hearing or may rule on the request upon pleading. So right here, I'm going to show that there were several times where I motioned the court to get the audiovisual record, and they were totally ignored. But to continue right here, this is what I'm going to be teaching on today. I have these interrogatories in the file section of the FFF, as I showed you, and this is the federal rule of civil procedure when you're giving interrogatories to parties. All right. And I'm going to read Federal Rule 33, interrogatories to parties. Unless otherwise stipulated or ordered by the court, a party may serve on another party no more than 25 written interrogatories. We only have 19 in ours, including all discrete subparts. Leave to serve additional interrogatories may be granted to the extent consistent with this rule. All right. An interrogatory may relate to any matter that may be inquired to under rule. An interrogatory is not objectionable merely because it asks for an opinion or contention that relates to the fact or application of law to the fact. Right here, but the court may order that the interrogatory need not be answered until designated discovery is complete or until a pretrial conference or some other term. So it says responding party. The interrogatories must be answered. All right. So what child support does, they don't answer them anyway. They do what they want to do. But right here, the interrogatories, this is what they should be answered. You know what I mean? The party time to respond. The responding party must serve its answer and any objection within 30 days after being served with the interrogatory. This is the law. But of course, child support always breaks the law. Not only do, you know what I'm saying, they when it comes to all types of due process and slavery and peonage, but they break the law in many different ways. You have them do this type of stuff. Each interrogatory must, to the extent it is not objected to, be answered separately and fully in writing under oath. They hand me back an interrogatory disrespectfully. All right. The person who makes the answers must sign them. The attorney who objects to signing any and the attorney who objects is tying any objections. All right, so right here, we're seeing the rule right here that they're supposed to follow. Now we go to our interrogatories. The interrogatories that is now, of course, it's not going to have my name on it, you know. But as we can see, the interrogatories are, you know, mapped out so that they can understand that they're supposed to partake into it. Yeah, and talks about how it's paraphrased by child support a program manual, how it said in accordance with FRCP 33 that we just went over. And you are subject to respond to the following 19 interrogatories. Then I lay out the rules. The rules are laid out. Then we get to the first interrogatory, and this is like some of the questions that you would ask child support in regards to, let me zoom in a little better. These are questions you would ask child support. Okay. Number one, pursuant to 42 USC 654, the state plan for child and spouse support must provide for the establishment or designation of a single and separate organizational unit. Yeah, okay. So right here is really basically saying that child support is not part of the government. You know, we talk about the Social Security Act, but in regards, child support enforcement agency is a single and separate entity from the state. And okay, but it works with the state. It's a franchise. But we're gonna continue. The 42 USC 654 4D child support enforcement agency performs its duties under the executive branch of government and is not a part of the judicial branch. You want her to answer that. You want him to answer, is child support part of the executive branch or the judicial branch? What you find out is it's a part of the executive branch, but it bribes the judicial branch with contracts. You check out the live I just did before this one. I showed the contract where Child Support Enforcement Agency has contracted with the juvenile court. So, which is totally against the separation of powers doctrine and it's treason, but it's treason for pay. The interrogatories 3, pursuant to 1 USC 204, those titles of the code which are not enacted into positive law are considered prima facie evidence of the enacted law and are presumed to be law prohibited by a due process clause. Okay, right here it's just saying that these codes, these child support is under the Social Security Act was not enacted into positive law and are considered prima facie evidence. Like it's not law, and especially when it's challenged, it's not law. It's assumed law. They assume it to be law and are presumed to be law prohibited by the due process clause. And there's no due process when it comes to child support. Title 42 of the U.S. Codes, which houses the 4D of the Social Security Act, is not acted in the positive law and imposes no obligation upon those who do not volunteer or consent to be subject to it. This is a question. This is a question inside of their laws that we're supposed to volunteer and consent to this. Well, you know what I mean? That's why they don't never want you to read it. Like I said, I went to the court and read where it said that we're supposed to have a personal responsibility contract inside of the Social Security Act, and they did not want me to read the law. So that what goes on with, you know, this type of wickedness. But to continue, pursuant to 45 CFR 303.107, requirements of cooperative agreements contain a clear description of the specific duties, functions, and responsibilities of each party of the appropriate courts and law enforcement officials, and specify that the parties will comply with Title 4D child support of the Act and specify the financial arrangement and procedures for billing child support for relevant federal and state reimbursement, and specify the dates in which the contract begins and ends. All this was not specified. The most they did was send something to my house. I didn't even have to sign it. The fact that it didn't come back to them, they contracted with me. With this Title 4D lies. But we can continue with that. Interrogatory 6. Let me see this right here. The stigma attached to injured party in connection with his injuries is the consequence of a contract between federal and state governments under 31 U.S. Code 6305, and it's a lot of words, which are sources of the legal collection actions for TANF loans conducted by the 4D agency, the courts, and law enforcement agencies whose acts represent child support collection systems. Such conduct was done under the contract, causing the infringement of petitioners' inherent rights protected under the Constitution. Therefore, the offender may not assert the good faith of his officers or agents as a defense to liability. Okay. So, and I'm gonna go to different ones, but basically that one's, I mean, it's talking about how in TANF you had different TANF loans and things of that nature, and like we're saying with Title 4A of different social security, when you're dealing with what was the welfare in regards to TANF and things of that nature. Title 4D agency was to recoup the monies and things of that nature, but it was done under the contract. So was it done under this contract, which I showed you all the contract they have right here in Interrogatory 7 in the 1997 Balanced Budget Act. Congress required states to implement procedures compelling the use of Social Security numbers pursuant to the Federal Child Support Enforcement Program. The Social Security is the key piece of information around which the child support information system is constructed. Computer searches needed the Social Security in order to operate efficiently. So right here is the Social Security number that binds you. Right here it says the Social Security Act. So if you get a business and conduct a business, and you don't use your Social Security, you use the EIN number, this they will not be able to take from you, as you can see. Social Security Act. You are required to disclose Social Security numbers to the Child Support Agency for the purposes of establishing paternity and establishing, modifying, enforcing support obligations and other child support enforcement agencies. Okay, so this is right here talking about interrogatories, Title 4D agency, Interrogatory 8. Therefore, the Title 4D agency requirement of Social Security number is a felony pursuant to 42 USC 408 penalties in general. Whoever compels the disclosure of the Social Security number of any person in violation of the laws of the United States or conspires to commit any offense described in any of the paragraphs 1 through 4 shall be guilty of a felony. Require to direct, order, demand, instruct, command, claim, compel, which is what we're being compelled, request, need, exact. So right here is what child support does. That's a felony. So we have interrogatories that are, spelling all this stuff out. And like I said, I urge you to go through the different interrogatories and see the different questions and get an understanding of what's going on with the different laws and what Title 4D is, which is child support. Interrogatories 9. In pursuing cases, child support officials try to obtain a great deal of information and several documents from the custodial parent or other sources. These include the name and Social Security of the non-custodial parent. Identity theft is an act of using a man's personal identifying information, i.e. name, Social Security number, account number, without his permission as a method to gain financial advantage or obtain credit and other benefits in that man's name and to his disadvantage or loss. And thus identity theft is promoted by a child support enforcement agency pursuant to the Federal Child Support Enforcement Program, Section 8, page 14. So yeah, we know this is identity theft, but they can admit it or deny it, and they need to answer the question separately as it says in that law. And you can send this to them and ask them, are they committing? Just see what they're going to say. All you have to do is make this yours, family. Change the name on there. Send it to change a different court. And you can send these to the court as well. Continuing. The 4D collection agency represents the county and does not represent the applicant and is not the applicant's attorney. And the applicant is a customer of the 4D collection agency. So this is a franchise. And we basically, with this interrogatory, they're trying to make the child support admit that they're not helping them. They're not the attorney for them. They're not representing the mother and the child at all. But the mother and the child are a customer and an applicant, because they do an application and they also have an application fee. So they are applicant. This is all this knowledge about the understanding of the workings of child support is in these interrogatories. It's good to get an understanding of what's going on with there. So this is making them tell the truth that no, even though, and if you notice, especially here in Hamilton County, the mother of my child has her lawyer and child support has their own lawyer with a computer, with a desktop computer at that, in the court. But as we already know, juvenile court bribes them millions of dollars. So of course, they would have a comfortable place in the child support court to sit and make sure that their investment and everything they're doing. Let's continue because I can ramble. Interrogatories 11. The extension of 4A, which is welfare, the extension of 4A loans to unwed needy women with children creates a debt due from a non-custodial parent to the creditor, Title 4D, in the amount of the Title 4A loan. Okay, 15 USC, and the rest of the numbers. The term creditor means any person who offers or extends credit creating a debt or whom a debt is owed. So it turns you into a debtor. And that's why they throw you in debtors prison, man, which is supposed to be illegal. A lot of brothers believe they go to jail because they didn't pay their child support. No, that's debtors prison. They really get you for, I guess, breach of contract or contempt of court, not showing up or things of that nature. But they cannot lock you up for not paying child support. That's debtors prison. But when people don't know, they do dirty things like that. All right. The 1974 legislative history of the Title 4D proves that Congress intended to extend assistance loans to unwed needy women and children with children. Congress enacted Title 4D for the primary purpose of recouping Title 4A loans extended to unwed needy women with children by recapturing said to the reimbursed state governments from non-custodial parents via voluntary acknowledgement of paternity contract. And that's and right there, it's also crazy because child support forged my name on my on the birth certificate, things like this. But this is right here is a voluntary acknowledgement of paternity contract. All right. There's just several more interrogatories. Right here it says pursuant to 45 CFR, by accepting cash or medical assistance loans, unwed needy women with children must assign all legal rights to support to 4D, child support, agency from any person. The purpose of the assignment scheme is to reimburse state government for assistance loans under 42 USC 666 operational law, which creates a debt due from the non-custodial parent in the amount of the extended 4A loan. Operational law is a manner in which rights and liabilities develop upon a person by mere application to the particular transaction of the established rules of law without the act of or cooperation of the party himself. These child support enforcement contracts are bill of attainder. And, you know, it's basically talking about involuntary servitude. But it also keeps reiterating that the Congress only intended to give states the ability to recoup Title 4A or welfare loans extended to needy unwed children with women with children. The courts have consistently ruled that Title 4D child support creates no enforceable rights for the unwed women with children because they are not in the intended beneficiaries of the statute. So there's no the women that really don't have no rights when it comes to collecting child support. If child support was to take all her money, they really have no rights because it was not intended for the women and the children. It was intended for the public treasury. It was intended for them to recoup money. So it was not about them. It was about making money because of the welfare that they were giving out. All right. And it has many different case law in regards to that. I'm gonna go because Congress merely believed that all children have the legal right to receive support. Instead, legal rights is not guaranteed or protected under the state of federal constitution to help children attain this legal right. Congress took action to improve paternity establishment in the Omnibus Budget Reconciliation Act of 1993. This law requires states to have in effect by October 1st, 1993, a simple civil process for voluntary acknowledging paternity under which the child support enforcement agency must explain the rights and responsibilities of acknowledging paternity. And pursuant to 45 CFR 303-101, the due process rights of the parties involved must be protected. Right here, we see that they broke this. They're supposed to explain the rights and responsibilities. Child support never explains the rights and responsibilities. They just put it on you. They don't, you know what I mean? So that doesn't happen. So we see how the court steals and goes against its own Omnibus Budget Reconciliation Act. They go against it. The due process means that they can't just come and take your money without you going to court and being able to fight, having some type of due process. But what happened is they take away due process. All of a sudden, the money's coming out your account. You're like, what happened? They don't even serve a process. You know what I mean? We talk about, sending certified letters to my house and things of that nature, letting me know. They didn't, when the first time anyone gets child support, they do it behind their back. There's only the magistrate and the judge there, and they both sign it. And in fact, well, my particular judge, she signed my first child support hearing. She signed my child support contract. I said hearing contract. I'm like, but then when I'm trying to I'm trying to set aside the magistrate order, I go see her, the same one that signed my contract. You know what I mean? Let me continue. As long as 45 CFR 303 explanation meets state due process requirements, it may be verbal or in writing. However, the Child Support Enforcement Agency knowingly failed to disclose that a man will be taking on the responsibility of paying back welfare loans extended to needy children, women and children to the Title 4D agency on acknowledgement form, other written material, or verbally. Therefore, by knowingly concealing the aforementioned consequences as a result, voluntarily signing the acknowledgement of paternity, the 4D agency did knowingly commit fraud and deceit of material facts, which arose from silence where there was a duty to speak the truth, as well as from speaking an untruth. So right here, yeah, it just brings them the task of what they're supposed to do. They're supposed to get you an understanding of your rights and responsibilities, and they do not do it at all. So they are very fraudulent. Pursuant to Child Support Enforcement Program, Section 8, paternity establishment is a prerequisite for obtaining a child support order. Paternity is legally established on the date both parents sign this contract. This contract allows a parent to seek a child support order without further court proceeding to establish paternity. Once signed, both parents and witness or notarize this form allegedly has the same binding effect as a court judgment of paternity, and without paternity established, children have no legal claim on their father's income. Yeah, well, I mean, they do what they want to do. So this is very good information. Okay, I'm gonna read the last one. Most states have placed a child support agency with a social or human services umbrella agency, which is also administers the TANF program. Others use the Office of Attorney General. An umbrella agency is a company that acts as an employer to an agency contractors who work under a fixed term contract assignment. So I always want them to right here, the last interrogatory is having them admit that they're the magistrates that work under there are contracted. And this is a certificate of service. You make sure you send it certified to the Department of Human. Well, actually, you don't even need. You should send it to the Child Support Enforcement Agency and the Juvenile Court. But Brother Benjamin.
Yeah, I had a question.
What's
I had a
up?
question. So you were saying that if you get a job and you working under the EIN, if I go get a job and work under my EIN, they basically can't try and take any child support from me because I'm working under that EIN.
Yeah, pretty much. They seek you out with the Social Security. Without the if you don't use the Social Security, then they can't find you. Now I know that some Social Securities are attached to like certain like businesses, but and I have to get an understanding of that. But from my understanding, when you go under LLC or things of that nature in an actual business, and they're paying your business opposed to you on a personal level, then you don't have to pay because they're paying the business, and that business is not you.
Okay, that makes sense. That makes sense. I knew a job that actually did that. They make because of what I do, they actually contract individuals and they have them go actually get an EIN. And I know that's how that parent locator work. It only goes, I think, off your social security,
Yeah.
social security number. Yeah, but you was asking me, you had a question for me?
Oh no. I was just saying overall, what do you think about the information? Did you learn anything new or anything like, or not new, but necessarily that come back to you, like, or information that you forgot about or just been a while or anything like that?
Yeah, I forgot about how detailed that interrogatories was, and I think it likes go give me a little bit of fuel. Excuse the noise. It's go give me a little bit of fuel to like, clap back or question back. When they send me these little threatening or crazy letters, it give me some information to work with and make me more knowledgeable on how they work or questions to ask them. You know what I'm saying, and trip them up a little bit. And it's that information is power. Knowledge is power. And that's one thing we got to arm up on is just this knowledge on just using their own system against them. Because I didn't know how illegal and fraudulent it was until you started to bring out all this stuff and show me the contracts and show me how people getting pay cuts and everything like that. I even got contacted by the sheriff office, them taking payments and stuff from me, seeing how much I can do. I've been fooled to where they claim they just wanted to bring me into court and see how come what was been going on. I've been slipping on payments. Come to find out they locked me up. You know what I'm saying? So, but yeah, all that's I would say just the detail of it and the information of it it's gonna be helpful down the line to me, and utilizing it.
And you know what? The main thing, even when it comes to my particular instance, the main thing I get from this is that you can attack how fucked up it is from different angles. And even though they know it's messed up, they know they do a bunch of lies, they know they break the law. That's why they continue to do it. But you know, that's why I really want the audio visual, and that's why I put that at the beginning, because you know, when you walk up in that courtroom, you have to know that courtroom is getting millions of dollars from child support. It says on the contract that like 3 different things, like used for collection, money collection, asset collection, arrears collection. So they're using these magistrates to get money. So they're going to do what they, you know what I mean, what they contracted to do, and that's make sure to take as much as possible from you. It even tell them that they have to at least take 20% from arrears recovery. You know what I'm saying? So it's even telling them how much to take from. So, you know, yeah, man. So it's good. It's good to have an understanding of what's going on and how these crooks are getting away. But we don't want to really get away with it. And basically, what's going on now is my simple request, and I'm gonna come up with a video soon. My simple request to get the audio visual recording was ignored many a times. And that's really all I want. That's because, see, if you have something like this, interrogatories, and you go to court and you present this information, when you get and you present it with the laws and the codes, and you also give them a notarized copy, you know, I mean, not a notarized copy, my bad, but a copy of it to make sure you deposit it in the court, then, you know what I mean, then basically you have shown them to be false, to be a liar, and to confound them. What they do what they want to do anyway, especially in that juvenile court, because they're bribed. And that's why I'm saying, like, man, I went there with one of the brothers. He gonna be on another time, the messianic brother, not my sergeant at arms. Man, he's seen how, you know what I mean, we came with the laws. I was only talking about the laws. I was only dealing with strictly with the paperwork, and I was professional. And they just told me flat out, I don't want to hear them laws. I don't want to hear that. You know what I mean? I was just shutting them down, but it's like, you know, but it's like at the end of the day, they're still gonna do what they want to do, regardless if you're right or wrong. So that's why I'm saying I want to gather the information. Now, you know what I mean? I am going, you know, to go to another court and things of nature. We've got to help. We got to hold these people responsible, man. You know what I mean? And people say, you know, you're supposed to go take them to the Supreme Court, do a complaint to the Supreme Court and things of that nature. You know, we definitely got to something has to be done, because they use this contract as having them come at me crazy. Like I didn't know that magistrate from a can of paint for him to come at me with all the type of anger and vitriol. I'm like, and he doing it for the money, because I don't know him. I mean, that's just his character. Like as soon as we are in a trial, he gets anti the person who's paying child support in the juvenile court. But yeah, man, that's what's up, man. Like I said, all we looking for now is just to get the evidence, man. We want to put this shit out, man. We want everybody to see and know and understand what's going on, man. Because that's the only reason they're getting away with all these fathers is the fact that they have no accountability, they have no oversight. You know what I mean? They do what they want to do. I got proof that I motioned the court, you know what I'm saying, and they just ignored it. They ignored hella motions, and I got them file stamped. They ignore them. I got the evidence that I put them in, but they ignored them anyway. But that's pretty much it, my brother. I'm about to end this one. Give all praises to the mighty Yah. Hallelujah. Praise Yah.